Does the United States Congress have the authority to regulate guns under the Commerce Clause? To find out, you have to read U.S. versus Lopez, but it's 59 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read. I cover landmark cases that have changed the landscape of American law in various controversial issues that are important to understand. This is an episode on the case of U.S. versus Lopez. This can be found at 514 U.S. 549, published by the United States Supreme Court on April 26th of 1995. The issue in this case is under what authority Congress can legislate guns using the commerce power. To understand what's going on in this case, you have to understand two different things. One, what the commerce power is, and one, what the Gun-Free School Zones Act of 1990 is. The commerce power can be found in the United States Constitution. It's under U.S. Constitution, Article 1, which is Congress's power, Section 8, which describes certain authority that Congress has, Clause 3. And Article 1, Section 8, Clause 3 says that the Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. That's the commerce power. And the other area of law you have to understand a little bit about is the Gun-Free School Zones Act of 1990, which made it illegal to possess a firearm within 1,000 feet of a school. And they didn't really attach any legislative findings to that statute, but it was passed, everyone understood, under the Commerce Clause, commerce power of Congress. What are the facts of this case? The facts are a 12th grader, a high schooler, went to a high school in San Antonio, Texas, in possession of a 38 millimeter handgun. And an anonymous tip was given to security who approached the child, stopped him, seized the gun, and he was prosecuted under that Gun-Free School Zones Act of 1990. He moved to dismiss, saying it was violation of the Constitution. The district court judge denied that application. The defendant waived the jury, and he was found guilty of a bench trial. He then appealed his conviction. This is the procedural history. He appealed his conviction. It went to the Fifth Circuit Court of Appeals, and they reversed it, saying it violated it was unconstitutional as it exceeded Congress's power to issue that kind of a criminal statute of the Gun-Free School Zones Act of 1990. The majority holding here by Chief Judge Rehnquist says this is a federalism case. Federalism says that there's a state government and a federal government, and that all the power that could possibly exist lives in the state government unless it's been carved out specifically by the U.S. Constitution and given to the federal government. And that's why the 10th Amendment to the Constitution says that all the powers not specifically given to the federal government in sum and substance are reserved to the states. So according to federalism, unless Congress has the specific authority to issue it, then Congress doesn't have that authority. It belongs to the states. So Judge Rehnquist says that there's only three broad categories that are covered by the Commerce Clause. Number one is the channels of interstate commerce, meaning like highways or trains, airports. Second is the instrumentalities of interstate commerce, things like hotels or restaurants that you might need if you're going to travel from New York to California. And third is Congress has the authority to, under the commerce power, to regulate activities that have a substantial relation to interstate commerce, that substantially affect interstate commerce. So Judge Rehnquist goes through those and says, obviously, it's not one or two. It's not a highway. It's not a train. It's also not a hotel or a restaurant. It's a thing. And unless that thing, a gun, substantially affects interstate commerce, then Congress doesn't have the power to regulate it. Here, according to Rehnquist, this is not something that substantially affects interstate commerce. It has nothing to do with interstate commerce. It's a wholly intrastate issue. It's local. It affects schools. It affects weapons. It's a police power. And that is the kind of thing that states have power to regulate. So according to Judge Rehnquist, it violates the federalism, and it's therefore an excess of the commerce power. Justice Kennedy, this is a 5-4 decision in this case. Judge Kennedy has a concurrence where he says that he has a slightly different reason why the statute's unconstitutional. He says because of federalism, not just the reasons that Rehnquist gives, he says it's important for civilians, for citizens to know who to hold responsible for bad laws. So he says education is a local area, police and the police power and crimes are a local area. It shouldn't be Congress regulating guns or issuing a gun control statute, because then the civilians, the voters, won't know who to hold responsible. They'll hold the state responsible by accident, even though the federal government is the one that passed the law. So he likes there to be a very big separation in areas of concern so that the voters know who they're voting for and can correct issues they don't like. Judge Thomas has a concurrence as well. He would eradicate the entire substantial effects test. He says for the first 150 years of the country, there was no substantial effects test. And only since the 1930s did it even exist. So he would eradicate that entire substantial effects part, that is substantial effects rubric. He would only go with the instrumentalities and the channels of commerce. But then we get to the dissents. Supreme Court Justice Stevens says that Congress can regulate guns near schools because children's education impacts our ability to create productive economic society and citizens. And therefore, it would result in changes in commerce with foreign nations and among the several states. So he would say that the actual text of the Commerce Clause would apply here, because if you don't regulate guns, you create an unsafe environment, and then it becomes hard to deal with foreign nations and among the several states, which is what the Commerce Clause specifically allows. Judge Souter has a different dissent. He says that the only questions they're supposed to ask are, is there a rational basis for the ruling? And are the means chosen by Congress reasonably adapted to the ends permitted by the Constitution? And then Judge Breyer has the main dissent here, and he says that Congress should be able to regulate guns, and they should not be found unconstitutional, because Congress could have a rational basis for finding that gun-related violence has a substantial connection to interstate commerce because it threatens teaching and learning, because schools are essential to creating a productive society, because schools spend a significant amount of money in the economy, because families choose where to live based upon how safe or violent a school district is. And also, Judge Breyer, he argues against the majority's distinction here between commercial and non-commercial. And finally, Judge Breyer thinks this is creating uncertainty in an area that was relatively certain. Why is this an important landmark case? It's a landmark case and an important one in the area of gun control because it's the first time since the 1930s that the Supreme Court held that, first of all, that Congress didn't have the authority under the Commerce Clause to act. And secondly, it's a gun case. This is a case where the majority holding says that Congress should not be regulating guns because they don't have the authority under the Commerce Clause. This is an important area to think about in terms of whether the federal government is the appropriate venue to regulate guns on a national basis, or whether more properly, according to the majority, this should be done on a state-by-state basis because that's where the police power is and that's where the education authority is. That's the case of U.S. versus Lopez. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.